The sheriff held the document at arm's length, reading it twice in the noon sun, while Karen Westfield's face went from red to something closer to ash. Behind him, 3 deputies stood with their hands near their belts, and behind them, 47 beach chairs sat in neat rows on sand that had been in my family since 1842. Karen had called them to arrest me for trespassing. What she didn't know, what none of them knew until that moment, was that the piece of paper I'd just handed over was a North Carolina Tideland grant signed by the governor's office in 1842, recorded in the Carteret County Register of Deeds, and very, very clear about who actually owned the first 200 feet of beach frontage at Gull Point. Not the Gull Point HOA. Not the resort developers who built the condos in 1987. Me. The sheriff looked up from the grant, looked at Karen, and said 5 words that I will remember until I die. "Ma'am, you need to leave. Let me take you back 6 weeks. I inherited the Gull Point property from my grandfather in March. A small cottage, weather gray siding, 40 yards from the high tide line. I hadn't been there in 15 years. The cottage needed work, but the land was sound, and I had time. My consulting contract had ended. My lease in Raleigh was month to month. I loaded my truck and drove east. The first week was quiet. I repaired the porch railing, replaced rotted window trim, and walked the beach every morning with coffee in a thermos that had been my grandfather's. The sand was white, the water was cold, and I didn't see another person before 10 a.m. The second week, I saw the chairs. 40, maybe 50 of them, arranged in rows starting about 30 feet from my porch and extending south along the waterline. Blue and white striped canvas. Little flags on poles. A catering tent. I walked down to the nearest chair and found a laminated sign zip-tied to the frame. Reserved for Gull Point Resort guests. Unauthorized use prohibited. A man in a polo shirt and lanyard approached before I could touch it. "Can I help you?" I asked who set up the chairs. He said the resort, same as every summer. I asked if they had a lease. He looked confused and said I need to talk to management. Management was Karen Westfield. She returned my call in 4 minutes. "The beach chairs are a resort amenity," she said. "They've been there for 35 years. If you have an issue, you can submit it in writing to the HOA. I told her I wasn't in the HOA. She laughed, actually laughed, and said everyone at Gull Point was in the HOA. It was part of the deed restrictions. I told her my deed predated the HOA by 145 years. The line went quiet. Then she said, "We'll see about that," and hung up. The next morning, I found a citation under my door. Violation of community beach use standards. Failure to register guest activity. Unauthorized structure within the resort view shed. They meant my cottage. Fine total, $1,200. I called my attorney. Paul Driscoll had handled my grandfather's estate. He was 70, spoke slowly, and forgot nothing. I read him the citation. He was quiet for a long time. Then he said, "Do you still have the metal box from the cottage closet?" I did. I hadn't opened it. "Open it," Paul said. Inside was a leather folio, crackling with age, and inside that was a single sheet of vellum, handwritten in iron gall ink, signed by Governor John Motley Moorhead, and sealed with red wax. It was a Tideland grant, issued to Captain Ezra Dalton in 1842, conveying ownership of the shoreline tract at Gull Point, described by metes and bounds, extending 200 feet from mean high water. Paul was silent for 30 seconds. Then he said, "Harper, do you know what you're holding?" I did not. "That's a colonial-era property instrument. It predates zoning law, it predates HOA covenants, and it's been recorded with the county since before the Civil War. If that description matches your current parcel, you don't just own the cottage. You own the beach." I looked out the window at the rows of blue and white. "Cheers," Paul said. "I need to make some calls." The survey crew arrived 3 days later. 2 men with tripods and a laser theodolite. They worked for 6 hours, cross-referencing the 1842 metes and bounds against modern GPS. When they finished, they handed me a map. The Tideland grant covered everything from the cottage to 200 feet seaward of the high tide line. Every single beach chair was on my land. Paul filed a quiet title action that afternoon. Karen received service 2 days later. She called me at 7 a.m. the next morning, screaming, "You can't do this. That beach has been public access for decades. We have rights." I told her she was welcome to present those rights in court. "We'll bury you in legal fees," she said. "We have an attorney on retainer." "Good," I said. He can explain to you what a Tideland grant is." She hung up. 1 hour later, I looked out my window and saw her standing in front of my cottage with a man in a suit, pointing. That's when I knew this wasn't over. The man in the suit was Bradley Vinson, and he arrived at my door 20 minutes after Karen left. He was polite, mid-50s, carrying a leather briefcase that looked like it cost more than my truck. He introduced himself as the Gull Point Resort's general counsel and asked if we could speak candidly. I invited him in. He sat at my kitchen table and laid out his position like he was presenting to a board. The resort had operated the beach amenity program since 1987. They'd invested over $200,000 in infrastructure. The chairs, the storage facility, the seasonal staffing. No one had objected in 37 years. "Surely," he said, "we could reach an accommodation." I asked what kind of accommodation he had in mind. He slid a paper across the table. "A licensing agreement. They'd pay me $12,000 a year for a revocable easement to continue the chair service." It was pre-signed by the resort manager. I read it twice. It was a clean offer. Reasonable money. No admission of fault. I could sign it, and the whole thing would go away. I slid it back. "No." Vincent's face didn't change. "May I ask why?" "Because my grandfather didn't spend 60 years paying taxes on this land, so a resort could lease it back to me." He nodded slowly, put the paper back in his briefcase, and stood. "I respect that. I hope you're prepared for what comes next." He was right to warn me. The HOA filed an emergency injunction 3 days later, claiming my quiet title action threatened public beach access and endangered a long-established community amenity. The hearing was set for the following Tuesday. Paul told me to bring the grant, the survey, and nothing else. "Let them talk," he said. "We'll respond with documents." The courtroom was small, wood-paneled, and packed. Karen sat in the front row with Vincent and 2 other attorneys. Behind them, at least 20 resort residents filled the gallery. I recognized some of them from the beach. They looked at me like I'd poisoned the water supply. The judge was named Harlow, a woman in her 60s with reading glasses on a chain. She read the HOA's filing in silence, then looked up. "Who's representing the respondent?" Paul stood. "Paul Driscoll, Your Honor." "Mr. Driscoll, good to see you. Do you have a response to the petitioner's claims?" Paul handed her the Tideland grant, the survey, and the recorded deed chain going back to 1842. "Your Honor, my client doesn't need to respond to the claims. He needs to establish his title, which predates the existence of the HOA, the resort, and the state of North Carolina as we know it." Harlow put on her glasses and read. The room was absolutely silent. She read the grant twice, examined the survey, and cross-referenced the deed index. Then she looked at Vincent. "Counselor, are you familiar with Tideland grants?" Vincent stood. "We are, Your Honor. However, we believe decades of uncontested public use have established a prescriptive easement." "On what basis?" "Continuous, open, and notorious use for over 30 years. Harlow looked at Paul. Paul smiled. "Your Honor, North Carolina law is clear. Prescriptive easements cannot be claimed against registered land when the title holder's superior interest is recorded and undisputed. Mr. Dalton's grant has been on file with Carteret County since 1842. The fact that the HOA didn't bother to check the records doesn't create an easement. It creates negligence." One of the resort residents gasped. Karen's face went red. Harlow made a note. "Mr. Vinson, do you have a recorded instrument showing your client's interest in the disputed parcel?" Vincent hesitated. "No, Your Honor. The resort's use has been based on historic practice." "Historic practice is not a deed," Harlow said. "Injunction denied. Quiet title action will proceed. Next hearing is set for June 14th. She gabbled. The room erupted. Karen stood up, shouting something I couldn't hear. Vincent put a hand on her shoulder. She shook it off and walked out. Paul leaned over. "They're going to escalate." I asked him what that meant. "It means they're going to make this personal." He was right. The next morning, I woke to find my truck's tires slashed. All 4. Security footage from a neighbor's camera caught a figure in a hoodie at 3 a.m., but the resolution was too poor for an ID. I filed a police report. The deputy took notes and said there wasn't much he could do without evidence. 2 days later, I received a code enforcement notice. 12 violations, ranging from non-permitted exterior paint color to unapproved vegetation. The inspector's name was local, but the complaint had been filed by the HOA. Paul told me not to worry. "They're flailing," he said. People don't file nuisance complaints when they think they're going to win. But the worst part wasn't the complaints. It was the neighbors. I'd wave at people on the beach and they'd turn away. One woman, someone I'd spoken to the week before, crossed the street when she saw me coming. At the general store, the clerk was cold. No small talk. No eye contact. I realized what had happened. Karen had painted me as the outsider trying to steal their beach. I wasn't defending my property. I was the villain. On June 10th, for days before the next hearing, I walked outside and found the chairs gone. Every single one. The sand was empty. I called Paul. He laughed. They're trying to moot the case. If there's no ongoing trespass, they'll argue there's no dispute. Does that work? Not even a little. The title question still stands. The hearing on the 14th was faster. Harlow granted the quiet title. My ownership was now a court-confirmed fact. Benson didn't even argue. Karen wasn't in the courtroom. I thought it was over. I was wrong. The chairs reappeared on June 20th. All of them. Same rows, same setup, same laminated sides. I stood on my porch at dawn and counted 53. I called Paul. He said to document everything and wait. They just violated a court order, he said. Let them hang themselves. I took photos, time-stamped and geotagged. Then I called the sheriff's office and reported a trespassing violation on my recorded, court-confirmed property. The deputy who answered said someone would be out within the hour. Sheriff Ray Kowalski arrived with 3 deputies at 11 a.m. He was a big man, late 40s, with the kind of voice that didn't need to be raised. He asked me to explain the situation. I handed him the court order, the Tideland grant, and the survey map. He read them in silence. Then he looked at the beach. Who set these up? The resort. Through the HOA. They know about the court order? Yes, sir. He nodded. Wait here. 10 minutes later, a black SUV pulled into the resort's main lot. Karen Westfield got out, followed by Bradley Vinson. They walked toward us across the sand. Karen's face was already set in fury. She didn't wait for the sheriff to speak. This is harassment. Mr. Dalton is abusing the legal system to interfere with a community amenity that's been in place for decades. We have every right to be here. Kowalski held up the court order. Ma'am, do you recognize this document? She glanced at it. That ruling is under appeal. Has the appeal been granted a stay? She hesitated. Not yet, but then this order stands, Kowalski said. And according to this order, Mr. Dalton owns this beach. You're trespassing. Karen's voice went shrill. We own the beach. The HOA has managed this land since, ma'am. Kowalski's voice didn't rise, but it cut through hers like a blade. I don't care what the HOA thinks it manages. I care about what the court says. And the court says this is private property. Benson stepped forward. Sheriff, we're prepared to negotiate. There's nothing to negotiate, I said. I hadn't planned to speak, but the words came out steady and clear. You were offered a chance to lease. You refused. You were given a court order. You ignored it. Now you're going to remove every chair, every tent, and every sign from my land, or I'm filing for contempt and damages. Karen turned on me. You can't do this. People have been coming here for 37 years, I said. I know. My family's been here for 182. Kowalski looked at Vincent. Counselor, I'm giving you 2 hours to clear this beach. If I come back and find anything still here, I'm citing your client for criminal trespassing. Vincent nodded tightly. Understood. Karen looked like she wanted to scream, but Vincent put a hand on her arm and steered her away. By 2 p.m., the beach was empty. I watched from the porch as a crew loaded the chairs into a truck. Karen supervised, her face carved from stone. She didn't look at me once. Paul called that evening. Vincent reached out. They want to settle. What are they offering? $50,000. One-time payment. They withdraw all filings, vacate the beach permanently, and issue a public acknowledgement of your title. I thought about it. And if I say no, they'll appeal. It'll take a year, cost them twice that in legal fees, and they'll lose. But they'll drag it out as long as they can. Tell them 75. And the acknowledgement goes in the county newspaper. Paul laughed. I'll call you back. The settlement closed on July 8th. $75,000, a recorded easement termination, and a quarter-page notice in the Carteret County News-Times confirming that the Tideland parcel at Gull Point was privately owned by Harper Dalton, per the 1842 grant. Karen Westfield resigned from the HOA 3 days later. Vincent stopped returning the resort manager's calls. The beach stayed empty. I didn't gloat. I didn't celebrate. I sat on the porch my grandfather built and drank coffee and watched the sun rise over water that had belonged to my family since before. There were surveyors to measure it. A few weeks later, a woman in her 70s stopped by. She introduced herself as Ellen, said she lived 2 streets over. "I owe you an apology," she said. "I believe what they told us. I didn't know the history." I told her it was all right. "No," she said. "It's not. But thank you for standing your ground." By August, people started waving again. The clerk at the store asked how the cottage repairs were going. A neighbor invited me to a cookout. Slowly, quietly, I stopped being the villain. I stayed through the fall. Fixed the roof, repainted the shutters, planted sea oats along the dune line. The beach was mine, but I didn't fence it. I didn't post signs. I just let it be what it had always been, a stretch of sand and sky that belonged to the land, and the land belonged to me. On the anniversary of my grandfather's death, I walked down to the waterline at dawn and stood where the Tideland grant said Captain Ezra Dalton had stood in 1842. The waves came in, cold and steady, and I thought about all the things we inherit without knowing their worth until someone tries to take them. I stayed until the sun cleared the horizon. Then I walked back to the cottage, made coffee in my grandfather's thermos, and got to work.